And good afternoon, everyone. Happy Saturday, and welcome back to Inside the Law. I'm your host, Philip Holloway. Today, we're going to have some fun. Today is for a couple of different reasons. As you can see, I have some different things around me. I'm in a little bit different of a space. I also am, for the first time ever, hopefully, if I've done it right, I'm streaming also on Locals in addition to Rumble. So if you'll give me a second, let me just check in over here on Locals and make sure that yeah, looks like we're streaming in all the places that we are supposed to be. I say that I'm not 100% sure now about Locals, but in any event, here we are. This is Saturday. What is today's date? Saturday, the 6th. Today is one day closer to when we find out whether or not the Georgia Court of Appeals is going to hear the disqualification motion brought by Donald Trump and Ashley Merchant and all the other good attorneys who are working on that effort. One thing that's happened this past week that I wanted to talk about is it looks like there's a brief been filed by the American Center for Law and Justice. Now, this is called an amicus brief. Now, let me see if I can bring this to the front of the screen for everybody to see. So we've got brief of the amicus curiae. Now, that's Latin, but what this means, this is what we call a friend of the court brief. Now, these are people who have some particular interest in the way an appeals court rules. In other words, they are weighing in. They're not part of the case. They're not defendants. They have no direct bearing, but they are allowed to give their opinions, if you will, to the court and urge the court to accept certain positions. The primary position that the amicus here, we call them the amici, that's the plural version. The amici are asking for the court is to take the very first step and to allow the appeal. You know, we've talked before, these pretrial appeals, they're called interlocutory appeals. Normally, when you have an appeal after a trial, it is everything. It comes up. It's after the trial. It's after people have been convicted. Sometimes people are in prison. And then you take all of the things that you think are error in the case, and then you send them all up together. But there are certain times and certain things that are so important that it has to be done before the trial takes place, because otherwise it would not make sense. Can you think about having to redo this trial all over again, or these multiple trials all over again, if it turns out that Judge McAfee was in fact wrong and Fani Willis should have been off the case? So there's lots of legal brain power being brought to bear on the issue of whether or not the Fani Willis has to be gone, whether or not she has a conflict of interest, whether she has forfeited her right to prosecute this case by virtue of her actions. That's a very important question. It's got to be addressed now. It's got to be addressed on the front end. So, by the way, before I go any further, I want to just introduce you guys. I told you, look, I've said in some previous streams, I said everything that, like all the super chats, all the memberships, everybody who joins, all of these things are for the purpose of making improvements to the channel. You see, I've got some different digs around me. What you see behind me is going to improve as well. But I'm in a different space. But I also have a little bit of tech support, and I want to introduce you right now to tech support Megan. Megan is helping with the chat. She's going to be helping me keep an eye on that so that we don't have to so that I don't get distracted looking at what's in the chat. She's handling a lot of that for me, and we really appreciate her help. Hi, how you doing today, Megan?
Hey guys, happy Saturday. Sorry about that.
All right. So anyway, thank you, and feel free to chime in anytime. But we're going to go ahead and get right back into this. We are going over the Now she's off stage. She can still hear, and she's still monitoring the things that are going on over here in the chat. All right, so here we go. We have the brief of the amicus curiae. And we see that it's Jordan Sekulow, the American Center of Law and Justice. All right, I'm not going to spend a lot of time on the table of authorities, table of consequences, table of authorities, and table of contents is what I should have said. But we have lots of case law. We can see they're citing cases from the United States Supreme Court, the Georgia Supreme Court, intermediate courts of appeal throughout the United States, Georgia Supreme Court again, Fulton County Superior Court. We have another U.S. Supreme Court case here, more from the U.S. Supreme Court, some Georgia statutes. And once again, we see a law review article. We've discussed this before. A law review article is a scholarly publication. This it's law reviews are run by law students at law schools. Oftentimes, the articles are written by upper class law students, but sometimes visiting professors or professors who are on faculty as well. All right, getting right down to it. What is the interest that these people have in this case? In other words, why are they here? What gives them the right to butt into this thing and to tell the Georgia courts how to do their business? Well, here they're telling you, okay, they're saying who they are and that they are an organization dedicated to the defense of constitutional liberties secured by law, including the integrity of our constitutional structure, the separation of powers. ACLJ attorneys have appeared often before the U.S. Supreme Court as counsel for parties such as the Colorado Republican State Central Committee, Heritage Foundation, Trump v. Vance, lots of other cases. Here they tell you their specific concern is the integrity and preservation of the judicial system in a case with national implications. I mean, I think we all can agree that integrity and preservation of the judicial system is a very, very important issue. And this is most certainly a case with national implications. The ACLJ files this brief on behalf of its members who reside in Georgia, as the district attorney at issue, Fonnie Willis, represents quite literally the entirety of the people of the state of Georgia. And that's true. As the prosecutor on behalf of the Fulton County DA's office, at the top of the indictment, it says state versus Trump and others. So she is the representative of the people of the state of Georgia. So these folks, the interveners, the amici, they're saying that they bring this on behalf of their members who they believe are not being properly represented by the Fulton District Attorney. All right. And they say on that these people that they represent are concerned that their ability to meaningfully vote for president might be hampered by a politically motivated and infected prosecution, still very much bearing, here it is, an odor of mendacity. To preserve justice and to keep confidence in the judicial process, the amicus curiae urged the court to grant review. And here they get into the reasons why. The Court of Appeals should grant review of the Superior Court's decision. In other words, they should take the appeal because they say that it's necessary to prevent the maladministration of justice. The maladministration of justice. By granting review to correct the trial court's failure to disqualify the DA based on a glaring conflict of interest, or at a minimum, the appearance of conflict of interest. This court, and by that they mean the Court of Appeals, discretion to grant review gives it the authority to correct an order, listen to this, of such importance to the case that immediate review should be had. The case presents a question. The existence of a conflict of interest, including an apparent conflict of interest, is an issue of such structural magnitude that it affects the entirety of a criminal proceeding. Now, let me pause for just a minute. Let me talk to you about in a more garden variety case. Let's say somebody's driving their car down Interstate 75 through Atlanta, Georgia. They get pulled over. The Georgia Highway Patrol searches that car and they find some type of contraband. Let's just call it a kilogram of cocaine in the trunk. Okay. And let's say that the search of that car and the seizure of those of the contraband is unlawful in violation of the Fourth Amendment. But let's also say that the trial judge says, no, it's fine. It's fine. There is no constitutional violation. We don't have to throw out the evidence. It can be used in the trial. The person goes to trial. The person gets convicted. The person gets sent to prison. And then on appeal, the new lawyers come in and they say, wait a minute, the judge got it wrong. This was, in fact, an unlawful search and seizure. And we're going to include that judge's ruling along with everything else when we file our appeal to this conviction. And fast forward 3 or 4 or 5, maybe the Court of Appeal says, you know what, you're right. That was an illegal search. We're going to reverse the conviction and we're going to send it back to the trial court for a new trial. And, you know, it just doesn't mean that the defendant gets out of jail. It doesn't mean that he's not guilty. It just means that you got to go back and have another trial, this time without the cocaine evidence, if that's even possible. So what they're saying here, bringing it back to this issue, what they're saying is that this is so important that it can't wait until after a trial. Because if the prosecuting attorney is not supposed to be on the case, we can't go through months and months or years and years of litigation and potential convictions and potential prison sentences for some of these defendants if the prosecutor shouldn't be on the case from the very beginning. And so it's so important we can't do it the normal way. The normal way is bad enough because people go to prison before they find out that the court's made a mistake. But this is even worse, they're saying, because of everything that's involved. It's so important that we have to address the error before there's a trial. All right, moving on. A conflicted prosecutor who nonetheless proceeds with prosecution casts this, here we go, this odor of mendacity over the entire proceeding that cannot be corrected or remedied after the fact. Beyond its unconstitutionally injurious impact on the defendants, the odor negatively impacts the public's perception of and confidence in the judicial system, especially when the prosecution is that of a leading national candidate for the highest office in the land. This, they say, is a structural defect and can only be corrected immediately by rooting out all sources of the conflict. Neither a slap on the wrist nor removal of some of the conflict will suffice. Well, what are they talking about here? Here they're talking about Nathan Wade. They're talking about Nathan Wade being the one who was simply removed. In other words, the judge says, we've got this problem. We've got this odor of mendacity. We've got this pall hanging over the case of financial irregularities. And he had lots of other very colorful descriptions that I think painted a good picture of what is wrong with this case and the reasons why. Regardless of how you feel about Trump or anybody else in this case, anybody objectively looking into this case cannot reasonably be expected to have confidence in the result. If anybody gets convicted or if anybody gets acquitted because of what she has done, because of what Fani Willis has done, she has caused this case to be so structurally unsound that there can be no public confidence in the result. And half measures, such as letting Nathan Wade just leave the case, but leaving everything else. Look, it's like if you step in dog crap outside, and you walk away from it, or maybe you wipe off your shoe still stinks, and you haven't corrected the problem. So basically what this is Fonnie has stepped in it, and she stepped in it in a smelly way. And half measures like getting rid of Nathan Wade is not enough to undo the damage that she did. I hope that makes sense to everybody. Thank you for some of the good questions over here. Let me pause here and take a look at some of these that Megan has flagged for me here. What happened to the amicus brief written by Ed Meese to SCOTUS? I don't know. I'm going to have to look into that and come back. I'm not familiar with that. This next one, do you think she will recuse herself before Monday, or do you think she will rebel and stay? I don't know what's supposed to happen on Monday. I know that Harrison Floyd has been giving her some deadlines. I think he's poking the bear, but I don't think there's anything that's going to come to pass between now and Monday. Look, wild horses could not drag her away from this case. She is so personally invested. She is emotionally invested. She wants this case, and she wants to stay on it. Listen, all you got to do is look at her public comments and the things that she said to the news media just in the last few weeks, and you'll know that she's not going anywhere. She just doesn't have it in her to let it go. I mean, in a few minutes, we're going to talk about the merch store. Okay. If you've been following this on social media or following me on Twitter, we've got new information out that she is now doubling down. She's selling merchandise to support her campaign, and you won't believe some of the stuff. We're going to get into that here in a few minutes as well. By the way, I see we have 1,100 people in here. That's great, and I hope it grows. Right now, before we move on, please hit like. It won't cost you a dime. The likes make a big difference, and it's easy to do. Just hit like. And by the way, while you're here, if you're not a subscriber, go ahead and subscribe. And by the way, join the channel or go over and join Locals. We'd love to have you. All of the support helps because we are a work in progress. We're building this channel. We still have a good ways to go. But everything that you do helps. But if nothing else, please take a minute and hit that like button. I really, really appreciate it. All right. Let's get back into where we were. Let me check over here on Locals, and Locals tells me the stream has not started. Bear with me, guys. Let me see. Okay. Actually, I do think that Locals is, in fact, working properly. I'm a beginner. Y'all bear with me, okay? I've not Huntley and Viva and Nate and some of those guys have turned me onto this, and they're telling me that, oh, it's real simple to use, and I'm sure it is once you've got the experience that they have, but I'm just trying to make sure that I know how to do it right and that I don't screw it up. All right, anyway, back over here, back to the amicus curiae brief. As the United States Supreme Court has noted, some errors, again, they're saying the judge made an error, are so fundamental and pervasive they require reversal without regard to the facts and circumstances of the particular case. An error is fundamental if it undermines confidence in the integrity of the criminal proceeding. So ask yourselves, knowing what we've know now and seeing what we've seen for the last several weeks, can it be reasonably argued that if Fani Willis stays on this case, that there can be any degree of confidence in the integrity of the end result of this system? And I submit the answer is hell no. There's just no way. I mean, you can't just get rid of just a small piece of this problem, which was, letting Nathan Wade go and allowing the person who is in Fani Willis is in charge of him. She was the one that made the decisions that led to all of this. It's not about what she did in the bedroom with him. It's not about her personal relationship with him. It's about her sending him, no bid government contracts, benefiting from those things, continuing to carry on this affair, even after it was known, and then not being truthful about it. She ran in that courtroom like a wildcat with her hair on fire, just insisting to testify. And she took the stand, and she acted like someone who was just completely out of control. That's not the kind of calm, collected, measured prosecutor that we want at the helm of the most serious of our cases. Look, Fulton County, believe it or not, handles things other than racketeering cases. I know you're shocked, but in Atlanta, we've got murders. We've got armed robberies. We've got kidnappings. We've got home invasions. We've got burglaries. We've got gangs. We've got drugs. We've got all sorts of serious criminal problems. Is this the kind of person? Is this the personality? Is this what we want in charge of the office that exists to keep the citizens of Fulton County safe from these kind of violent criminals? Just look at her behavior, her demeanor as she took the stand, and ask yourself, if she stays in this case, can we have any confidence in the results? And I think the answer has to be no. Moving along. So the in here, I think, are really, really good. Some of them are dovetailing with the arguments made by the defendants who are bringing the case up on appeal. Here they point out that even an appearance of impropriety is unacceptable in criminal cases and erodes confidence in the judicial process. The United States Supreme Court emphasized that even the appearance of impropriety can be constitutional grounds for the disqualification of a prosecutor. An appearance is just as dangerous to a criminal proceeding and to the integrity of the judicial system as any other conflict, because such a conflict still pervades the trial and prevents the administration of justice. A prosecutor impaired by an actual or an apparent conflict has created a structural error affecting the entire process of a criminal proceeding. Appointment of an interested prosecutor is also an error whose effects are pervasive. Before I move on, let's talk about what that means. What is an interested prosecutor? We all have a right to certain things. If we're ever caught up in the justice system, you got a right to a jury trial. You got a right to a fair jury trial, for that matter. You got a right to be presumed innocent. You got a right to make the state prove your guilt beyond a reasonable doubt if they can. If they can't, you go free. You've got a right to a lawyer. You've got a right to a lot of things, but you have at its core, you have the right to fundamental fairness. The process itself has to be fundamentally fair. This is called substantive due process. It's found in the Fifth Amendment and the 14th Amendment to the Constitution. Fundamental fairness. It begins with the prosecutor. Okay? The prosecutor is the person who is in charge of stirring up the grand jury, bringing cases before the grand jury, deciding who the targets are going to be of the grand jury. And if that prosecutor is not operating first and foremost from a place of fundamental fairness, then everything else is garbage. Garbage in, garbage out. That's what the computer programmers say. If the prosecutor is tainted, pardon the pun, pardon any mental images that might be forming, but if the prosecutor is tainted, then the process is tainted. If the process is tainted, we cannot have any confidence in the result. So this is what they're talking about. The appointment, or in some cases, the election of such a prosecutor, calls into question and therefore requires scrutiny of the conduct of the entire prosecution, rather than simply a discrete prosecutorial decision. So there you have it. It's particularly necessary to hold prosecutors accountable for their conflicts of interest, because if the prosecutor exercises considerable discretion in matters such as the determination of which persons should be targets of the investigation, which persons should be charged with what offenses, which persons should be utilized as witnesses, whether and who should be granted immunity. Unlike evidentiary defects that can be fixed by a judge, the harm that results from a conflicted prosecutor permeates the entire proceeding. Prosecutors have so much power, and it's almost completely unchecked. Here we are witnessing lawyers fighting tooth and nail to get the courts to rein in and to check a prosecutor just a little bit. And it's like pulling teeth to make it happen. That's how much power these individuals have. They're more powerful than the judges, because the judges don't get to decide who brings charges. The judges don't control the grand jury. The prosecutors do. Between the private life of the citizen and the public glare of criminal accusation stands the prosecutor. Employ the full machinery of the state in scrutinizing any given individual, even if a defendant is ultimately acquitted. Forced immersion in criminal investigation and adjudication is a wrenching disruption of everyday life. For this reason, we must have assurance that those who would wield this power would be guided solely by their sense of public responsibility for the attainment of justice. So ask yourselves, from what we've seen, was Fani Willis guided solely by her sense of public responsibility, or was she guided by something else? And if she was guided by something else, she's got to go. I can tell you from having witnessed in my career up close and personal more times than I really care to talk about or to remember, I've witnessed what this system can do when they say here in this language that forced immersion in a criminal investigation and adjudication is a wrenching disruption of everyday life. Remember, people are presumed innocent, right? But you get wrapped up in these things and you get the full force and brunt of the state and all of its machinery just running you over. And this goes on for years and years and years. And even if you're ultimately found not guilty, oftentimes you've been destroyed by it. So she has the power to destroy people, even if she can't convict them. And this is the real justice system that I'm trying to explain to my audience. This is what I want you to understand is the real world that is not what you see on TV. It's a lot uglier. It's you peel back the layers of the onion, and every bit you peel back, it just stinks worse and worse and worse. The awesome power of the state to prosecute people. Now, don't get me wrong. We need prosecutors. We need police. We need jails. We need people to be put under the jail. Don't get me wrong. But we also this whole thing must start with prosecutors who understand the significance of the power that they wield, and they must be the kind of people that we can trust to wield it fairly, justly, and not in a way that singles out any individual person. It's got to be done objectively and fairly. And without that, you don't get to a trial. You don't get to talk about who's guilty or who's innocent, because you got to have a fair process or the whole thing breaks down before it even gets started. All right, moving along. Sometimes I get on a soapbox. Sorry about that. The Georgia courts have embraced the structural importance of preventing conflicts of interest, apparent or actual, and have made clear that an appearance of impropriety may certainly constitute grounds for the disqualification of a prosecutor. Now, you remember all this discussion in court when we had the court hearings on this, and everybody was quibbling about, do we need an actual conflict of interest or maybe the appearance of a conflict of interest? Well, guess what? Appearance of a conflict of interest is enough. Right here, the Georgia Supreme Court tells us so, and it's a recent case from 2017. That's all you need to know. It's right there. A an appearance of impropriety is enough to constitute grounds for disqualification. Battle v. State. That comes from Georgia Supreme Court in 2017. And they're quoted as saying, certainly a conflict of interest or the appearance of impropriety from a close personal relationship, in this case with the victim, may be grounds for disqualification of a prosecutor. This standard is time honored. And look, we're going back in history to 1852. Back in 1852, the Georgia Supreme Court emphasized that the administration of law should be free from all temptation and suspicion, so far as human agency is capable of accomplishing that object. 1852, free from all temptation and suspicion. Was Fannie Willis tempted? I mean, I'm not talking about tempted by Nathan Wade, because certainly, apparently she was, but was she tempted to use and wield the awesome power of her office in a way that benefited her personally, or that benefited her politically, or that helped to cause her political or personal star to rise? I submit to you that what we have seen so far, the answer to all that must be yes. And so on the basis of those things, back in 1852, the court disqualified former Solicitor General, which is a type of prosecutor, from representing defendants that he had charged during his time as a prosecutor, even though his term had since expired. So apparently a prosecutor went out in private practice, and so they said, no, you can't defend people that you once prosecuted because of the appearance of a conflict of interest, even if it's not actual. So this is a very, very, very well-written, thought out, legally researched brief. I mean, I could just read from this on and on and on, but I'll put you to sleep. The bottom line is that, well, here's something that's worth talking about. When you read these things where it says, as the court below acknowledged, what they're talking about, the court below is Scott McAfee. That's the trial court. As the court below acknowledged, even when no actual conflict exists, a of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. He acknowledges correctly that the judicial branch is the weakest of the three branches. And he acknowledges that even when there's the perception of a conflict of interest, that it further weakens the courts. But he didn't do anything about it. That's one of the things that's so frustrating to me about this judge's order. He gets most of it right. He gets it right that it's it smells bad, it looks bad, it tastes bad, it's got the odor of mendacity, it's got the pall of financial irregularity, it stinks to high heaven. That Willis was improper when she went down to the well of that church and she said God was inspiring her to do God's work, and that the defendants who were challenging this were all racist. That was wrong and it was improper. The judge even said so, but he didn't do anything about it. All he did was say, well, maybe it's time to put her in put a gag order on her. And I don't get it. If you find all of these things that are wrong, but you don't do a damn thing about it except say, okay, well, Nathan Wade might want to just go away. That's not enough. And that's what this is all about. That's what these lawyers are saying. And look, all it takes is one judge on the Court of Appeals to agree with what I just said. And then the appeal happens. The appeal happens in the Court of Appeals. And then if you get one more judge on top of the one that voted to hear it, that agrees, that more needs to be done, that simply getting rid of Nathan Wade doesn't unstank this place, doesn't clear up this odor of mendacity, then she's got to go. Okay. So it just takes two individuals at the Court of Appeals who see it the way these lawyers who wrote this amicus brief see it, and how I see it, and how the lawyers who wrote the appeal see it. If you just get two of them down there, Fanny's gone. Fanny's gone. And I think she's going to be gone. I really do. Moving on, there's a couple of things in here that I wanted to point out. Here it is. The court should ensure, yeah, this is good. All right. The court should ensure that the odor of mendacity that pervades this case is removed before it's too late. Before it's too late. The question is not whether an appearance of conflict of interest exists. The trial court made that finding. Okay. And once the trial court makes that finding, then that's the finding for the appeal. But under an abuse of discretion standard, says we are to review the trial court's legal holdings, denote holding, and a factual determination. So the factual determination is that there was an appearance of a conflict or of impropriety. What these lawyers here are doing is they're reminding the judges on the Court of Appeals that you're not bound by the judge's legal decisions. You are bound by his factual determinations, which are very helpful, by the way, to the appellants, but you are not bound by his legal conclusions that he draws. In other words, he drew the legal conclusion that just getting rid of Wade's good enough. Well, they're not bound by that. And that's what they're reminding them of. The question instead is whether from such an appearance of conflict, or whether such an appearance of conflict can in fact be cured while the very prosecutor who created that conflict by repeatedly making bad choices and creating an odor of mendacity remains on the case. The trial court sought to correct the conflict by simply requiring that either the district attorney or the attorney with which the district attorney engaged in a relationship withdraw. But that remedial action remediates nothing, and it's insufficient to correct the constitutional problems that exist here. That's it in a nutshell. That's it in a nutshell. The very prosecutor who created this problem and made the bad choices over and over and over again, the one who created this odor of mendacity, the one that barged in the courtroom testifying like a wildcat with her hair on fire, she's the one that caused this. And the judge's effort to try to correct all that by simply, engaging in half measures, allowing the subordinate attorney to withdraw, but not the person whose decisions caused all this, that doesn't fix it. Doesn't fix it at all. The Superior Court ruled that the district attorney's conduct created a significant appearance of impropriety, and Judge McAfee was correct. It does create a significant appearance of impropriety that infects the current structure of the prosecution team. Nonetheless, the court declined to remove the DA from the case. Herein lies the error in the court's decision. The Superior Court's finding that an appearance of a conflict of interest existed in the case was well supported. There's ample evidence, and they go through a lot of the evidence. We won't go through all of it again here, but it talks about the romantic relationship, whether and when it began, whether or not anybody lied about it. Also noteworthy, the court specifically concluded that the district attorney's testimony had not proven credible. Had not proven credible. This is what a judge says about the elected DA, not proven credible. Reasonable questions about whether the DA and her hand-selected lead SADA testified truthfully about the timing of their relationship further underpin the finding of an appearance of impropriety. The defendant's actions did not end there. The Superior Court also found that the DA's conduct of giving a speech and commenting extensively on this very case was legally improper, adding that providing this type of public comment creates dangerous waters for the district attorney to wade further into. But as we've talked about previously on this channel, She keeps waiting. She's getting deeper and deeper and deeper. These factual findings serve as the basis for which this court should examine the case. After detailed examination of the witnesses and lengthy testimony, the court found that Willis' actions had created the appearance of impropriety and that an odor of mendacity was still present in the case, as well as the continuing possibility that an outsider, that's us, looking in, could reasonably think that the district attorney was not exercising her independent professional judgment, totally free of compromising influences. Well, what kind of compromising influences could it be? Could it be that she wanted to get somebody in particular? Could it be that she wanted to make a name for herself? Could it be that she wanted to enrich herself by having her boyfriend pay for her travel with the money that she's steering to him at inflated rates? Could it be that she was paying tens of thousands of dollars of taxpayers' money to media monitoring companies to make sure that her media star rose fast enough and far enough and high enough for her? Could those be the conflicting and compromising influences that they're talking about? The United States Supreme Court is clear: once a conflict of interest, including an apparent conflict of interest, is established, we have deemed the prosecutor subject to influences that undermine confidence that a prosecution can be conducted in a disinterested fashion. And they go and look, and these lawyers, they're not done. They cite lots of good cases with lots of good language that all supports the same conclusion. And apparently there was some case law relied on by McAfee that was civil in nature, and then as opposed to criminal cases. And they point out that they say, look, but those are civil cases with very different dynamics and different constitutional policy interests at stake. For one, civil cases do not involve state actors representing the entire body politic of a sovereign state. In other words, the lawyers in civil cases represent their individual clients. An elected DA represents the people of the state of Georgia or the state of whatever, Tennessee, wherever. But the elected DA represents the entirety of the body politic, the people of that state. Life and liberty are not on the table in a civil case, except if it's Nathan Wade's divorce case where he's cited for contempt. Possibly liberty could be on the table there if the judge finds that he's in contempt and if the judge decides to put him in jail for not doing what he was told to do. But I digress. Underscoring the material difference between civil and criminal conflicts, a conflict of interest among private parties affects only those parties and can accordingly be waived. A conflict of interest in a criminal proceeding affects our interests, the public's interest in the faithful administration of the laws. In no circumstances can it be waived by that public. The continuance of a prosecutor on a case, despite the odor of mendacity emanating from the appearance of impropriety. Now that's interesting. The odor of mendacity emanating from the appearance of impropriety is an error pervasively affecting an entire proceeding. It is a drastic error for which only one remedy, and it's a drastic one, is the replacement of the prosecutor. Disqualification cannot be based merely on a harmful error analysis. A concern for actual prejudice in such circumstances misses the point. For what is, however, at stake is the public perception of the integrity of our criminal justice system. It is not lawful nor consistent with public policy nor with sound professional ethics for a prosecutor to continue in a case despite the appearance of a conflict of interest, regardless of whether anything intentionally wrong or unbecoming was intended. The intention is irrelevant. The administration of law should be free from all temptation and suspicion, so far as human agency is capable of accomplishing that object. All right. Well, that's it. I mean, it goes on for some other page, but you don't need to see the all the rest of it. That's it. That is the very, very well written, in my view, amicus curiae brief that was put together by American Center for Law and Justice. All right. So I'm sure you're tired of hearing me talk on and on and on for 30 or 40 minutes. I want to take a minute to, first off, grab a sip of tea, but also want to see if we've got some good questions. I'll look like I've got a lot of things that have been starred. What do we need to start with, Megan? What should we look at? Do we think that with all of the other improprieties going on in many courts of the nation, that it's actually possible to recover the confidence in our judicial and legal systems? Robert, I don't know. I hope so. By the way, I now see we have 1,700 and some change people in here. Thank you very much. I really appreciate. Please hit that like button. Consider subscribing as well, and even joining, because your support it means the world, and it will really help us grow this channel and to be able to provide better content moving forward. So thank you all very much. Please hit that like button. We've got, all right. Do you think she will recuse herself? No, we talked about that one. What happened to we talked about the amicus. I don't know what's going on with Ed Meese's amicus brief. I apologize. I'll have to come back to that. How can our system allow a DA to process that has, how can our system allow a DA to process that has to prosecute that has a vendetta against a defendant? Well, that's the $64,000 question. And that's what these lawyers are fighting so hard to try to undo. That's why they're trying to get her tossed off the case, because they've recognized that she does have that vendetta, along with other prosecutors that we've seen that might have a vendetta. That's not how it's supposed to work. And so these lawyers, admirably, in my opinion, are doing everything they can to try to remedy it. But you can see, there are some people that are not, they're not made of money. Trump may have some money. Some of the others might be, they might have money, but some of these individuals are just, I know more than one of these defendants personally, and they are not people that are wealthy people. And what wealth they might have accumulated throughout their lives is gone now, because they've had to spend all of it, their retirement savings, just on hiring lawyers to defend against this. So a prosecutor with a vendetta is a very, very dangerous breed of cat. All right. Tom, how much confidence could anybody have if you've seen any of this or YSL? We're going to be talking more about YSL, but it's important to remember that the Young Thug trial, the YSL, Young Slime Life, is it's the name of the trial. It's another giant RICO case that Fannie Willis and her office are trying to force down the throats of the Fulton County court system. And it's about to come off the chains. And let me just show you one example of how it's coming off the chains.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break soon. Hang in there.
All right, so that is a state's witness just from a couple of weeks ago. This is somebody who is supposedly there because these individuals are on trial for their very lives, and it's a state's witness. How in the world are you, a prosecutor, bringing that witness to court, asking ladies and gentlemen of the jury to please find somebody guilty based on that shit? This is ridiculous. And if this is how this prosecutor's office is being run, it's despicable. It's funny to watch that, but it's not funny because you have to think about this is Fonnie Willis's office, and this is what she's, her employee, her prosecutor is calling this witness. All right. Hey, look at there. Thank you, Republic Super Chats. Always appreciated. Thank you. Thank you very much. Phil, if you tell me it's a G, I'm giving you $1,000. Thank you for your breakdowns. I'm glad that Fannie was arrogant enough to burst into that courtroom. We never would have known the levels. I'll never forget that either, because normally witnesses are supposed to wait outside the courtroom. You're not supposed to be there to watch whatever's going on in the courtroom. You're not supposed to be watching it from the TV down the hall or up in your office. It's called the rule of sequestration, and it exists for a reason, so people can't get their story straight. And so we were in the middle of Anna Cross, the prosecutor, was asking the judge to quash the subpoena served on Willis by Ashley Merchant so that Willis wouldn't have to testify. But apparently she was so pissed off after watching the testimony of Nathan Wade and how he was kind of beat up on a little bit by, the defense lawyers, that she just stormed in that courtroom and she picked up those papers. She started slamming them around, and she was saying to Ashley Merchant, you're a liar. You're a liar. You lied in this, you lied in that. And she was not respectful to the judge. She was not respectful to the process. And that gives you a glimpse, I think, inside her overall personality, in terms of who she is as a lawyer. And it's not the kind of way that I was taught that lawyers are supposed to behave in a courtroom. I'll tell you that. So we did get a glimpse of some of where she was coming from. And if she hadn't done that, you're right, we would not have known. New member. Thank you, Laura. Kash Patel will be Trump's AG. He said they're going after the lying media and these corrupt AGs, judges, and politicians. I don't know. I want to limit as much as we can. You can't ever take when the case is literally about Donald Trump and other people. We can't completely, I think, take the politics out of it. But it's important to remember these discussions are about the process. I don't know who's going to win the election. I don't know what's going to happen if Donald Trump is tried before the election. So I doubt he's going to be, but I don't know how any of these other things are going to shake out. But what I'm here to talk to you about is the unfairness of this process. And if you can't have fairness in the process, as these lawyers have pointed out, you can't have confidence in the results of the system. It just can't. Will Steve Sadow's appeal Trump's free speech motion? Yes, one way or another, I think he will. He could potentially do it once the case is over. If it gets that far, he could do it in a pretrial way, like we've seen. Like we have seen so many other things going up on pretrial appeal. He could wait and rebring that motion at another time. He could bring it when after some more, if a factual record needs to be developed. In other words, they need to have evidence presented to the judge that says specifically what factual conduct is alleged by Trump that Sadow says is covered by the First Amendment. And once that record is made, the judge will have a little bit more information upon which to base his ruling. And he has said that he will revisit that issue. So it's going to come back up. The First Amendment issue is not dead. I promise you, it's coming back up. All right. I feel like maybe I've missed some things here. Megan's been doing a good job starring so many things. Let's get back over here into the live. Let's see. there's my friend Senior Chief again. All right. Carol's asking, how could the SCOTUS ruling on presidential immunity affect this circus? So I feel like any rulings on presidential immunity are going to have to do with immunity for official acts taken as president. So the argument would be, if I'm Donald Trump, that even though I'm a candidate in the case, and even though as a candidate, I've got an interest in the outcome of this election, I also am still the current president until I'm no longer the president, and therefore I've got to make sure that the elections are conducted fairly across the board in every state. So that's the essence of it. And so if the Supreme Court says that, checking in on and monitoring and even complaining about perceived problems with elections are something that's a legitimate use of time for the commander-in-chief to be doing, then a presidential immunity ruling, if it's strong enough and if it's broad enough, could absolutely wipe this case out and the other ones. But even if we don't get that far, this case, guys, is never, ever going to be brought to trial before this election. Okay. And then let's say Trump wins. Okay. Then Trump's never going to be put on trial. You're not going to put a sitting president on trial in Scott McAfee's courtroom, or if whoever beats Scott McAfee, if he's beaten in the election this year. He's not going to be sitting in a courtroom as a defendant in Fulton County while he's president of the United States. That's not going to happen. And so 4 years from now, assuming Trump wins, 4 years from now, he's not president anymore. Fani Willis may not be the DA anymore. She may not even be a lawyer anymore if the state bar gets a hold of her. So the dynamics of all of this are going to be very, very different. So I think that you're seeing the common theme across all of these cases, whether it's the Florida documents case, the cases in New York, this case here in Atlanta. You're seeing, and it's understandable, and I don't blame the lawyers, I would do it too. You're seeing everything that they can throw at this. And it's not frivolous things either. I mean, none of this that we've been talking about is frivolous. It's very, very, quite frankly, the opposite of frivolous. But it also serves to slow the process down. Think about the Young Thug trial. It took them over a year to pick a jury in that case. Can you imagine if we started tomorrow morning picking a jury in this Trump RICO case? It would take a year and a half, 2 years to pick a jury. So there's just no way that any trial is going to get underway. So Fani Willis I don't know what she's smoking if she thinks she's got something that she's going to get going this year. She keeps making noises about it. She's delusional. She's delusional if she thinks she's going to get a trial this year. All right. Young Thug trial is you're right. Young Thug is disheartening. Tomorrow, I'm going to be joined once again by Rachel Kaufman, who was here previously over the Young Thug trial. We're going to get an update on what the latest is with that. And also, we're going to get into what's going on. You guys won't believe what's going on in the Fulton County Jail. It is a death trap. We've had recent deaths in there over the last couple of days. Rachel has cases involving civil rights abuses in that death trap hellhole jail. We're going to talk about Young Thug and the Fulton County Jail with her tomorrow. So don't forget about that. Come back for that, please. It's going to be a very good discussion. So we're going to get into some of that. Thank you, by the way, Laura. We really, really appreciate the super chat. The question here. Thank you for taking your time to bring this truth to light in Georgia. I can't wait to see what happens with Harrison Floyd and the recorded phone call. Go get him. I don't know. Y'all must be referring to what Harrison put on Twitter yesterday or the day before. And on this channel, his lawyer said a couple of nights ago that they think that Fani Willis broke the law by recording the phone call between herself and one of his co-counsels, an attorney in Maryland. Georgia is we call it a one-party consent state, meaning that only one person on the line needs to know that it's recorded. As long as both people are in Georgia, that works fine. But if one person is not in Georgia, then I think the argument is that in this particular case, Maryland's law would presumably exist to protect the Maryland caller from being eavesdropped on. And I think Maryland law would not have deferred or whatever to Georgia law. In other words, if she's called him in Maryland, I think there's a good argument to be made that because Maryland is a two-party consent state instead of one, that she broke Maryland law. And I think that's the art. Now, what Harrison Floyd thinks he's going to do about it, I don't know. I've tried to get him to explain what kind of deadline are you giving her to do what? Are you just poking the bear, or are you risking another effort at Fani Willis trying to revoke your bond and put you in jail for some kind of shenanigans pertaining to poking the bear with her? I don't know, but whatever's going on, we ought to all be watching it. I know I will be, and we'll see what happens with Harrison Floyd and the phone call and all that. It's just another just bit of craziness in this case. All right, let me check in over here. Give me a second. Let me check in over here on locals and see what we've got going on over here. Interesting that the Georgia courts won't allow a former prosecutor to defend a client, but will allow a former defense attorney to prosecute a client. Well, it's, that's a former prosecutor can sometimes defend, like I'm a former prosecutor and I defend clients all the time. I've even defended people back in the day, but it was on some, but the two cases are entirely different. So these things that we're talking about, these are not always hard and fast rules. And a lot of times conflicts of interest when it comes to criminal defense attorneys vis-a-vis their clients, a lot of those things can be waived. All right. So sorry, guys. Just wanted to check in over at locals real quick. All right. Laura, we've talked to Laura. We've seen that. We've got another unhyphenated. Thank you very much for the super chat. No question, but obviously the support is greatly appreciated. Got almost 1,800 people in here. Please like and subscribe. Like, subscribe. Please consider joining as well. The support is appreciated. All right. I want to ask you guys a question, and please put it in the chat. The question I've got for you guys is based on my other videos. And with the understanding that what you see behind me is going to change, although my dog Winston might stay in my background. But other than that, what you're seeing and how I'm sounding, what you're seeing here, as far as quality goes, do you think it's better? Is it worse? Or is it about the same? Because again, this space that I'm now working in is it's a work in progress a little bit, but I'd like to know what you guys have to say about it. Yes, no, throw it all out and start over again, or am I moving in the right direction? Brian says it's good. Annie says fine quality. Keep Winston. No, I'm definitely going to keep Winston. Winston is there's Winston. He's a wire-haired pointing griffon. And he is the greatest dog. And this is an older picture of him, but I like it. I put it back there because there was some kind of a crazy plant, and I felt that for purposes of today, Winston would be better. But anyway, we're going to do something else better back here. We have when I raise my hands like this, my camera starts wanting to follow me around. So I've got to make sure I talk with my hands a little bit less. Typewriters. Yeah, this typewriter, I still write my legal briefs on this thing, if you can believe that. And if you do believe it, then I've got a bridge I want to sell you All right, we've got, what is this? Good question. We got, I guess the governor doesn't care about the reputation of Fulton County. So I want to clear this up, and I get this question a lot. And I understand the frustration with state leaders because, you know, Fonnie Willis is lower on the food chain than the state leaders. But Georgia being a former Confederate state, we had to, during Reconstruction after the Civil War, there were a lot of things that were imposed on the state government by the prevailing northern winners. And, you know, one thing that we had to do was to take a lot of the power out of the hands of governors. Particularly, one of the things was the power to, I guess, do clemency and parole and pardon, and all of that was vested in a state board of pardons and parole. So the governor's only role that he could play here is if Fannie Willis gets indicted by somebody, he then has the legal ability to suspend her. But unless or until that happens, the governor cannot do a damn thing about it. He just can't. It's not within his legal power to do it. So I understand the frustration. Absolutely, I do. But the governor, whatever you might think about the governor cannot do anything about Fonnie Willis, even if he were to want to. Typewriter makes me think of carbon paper and term papers. You remember those? Who else is old enough to remember those mimeograph things where, like, you know, you get them, you're in the class and your teachers would all say, let me go run off a bunch of papers for your homework. And they come back and they're wet and they smell like, you know, some kind of, I don't know, some type of chemical. And you get this wet paper and everybody wants to smell it, you know, when it comes by, because it was, what was that called? Was that called mimeograph? Is that the right word? That's something else I don't miss. I still prefer the word processor. I mean, that smell, I mean, it was the greatest smell in the world. We all loved it, but I haven't smelled it in forever. Winston will stay 100%. Winston's going to stay. All right. Oh yeah, that was the original, the odor of mendacity. All right. And the sound quality is better. All right. I appreciate that. I'm in a better, more soundproof room than I was. I've got, you can't see it because, well, the whole point is it's hidden. I have a hidden arm, for the microphone. So some of that's, is on purpose. So I promise you, I told you guys that some of the super chats, super thanks, the membership, the revenues or whatever from this, that I was putting almost all of it back in, and we still am, and not finished yet. But we are well on our way, and I thank you all for helping quite a bunch. Fulton County Election Board members that decided to certify. There was five of those guys. 2 of them voted against certifying the elections. 3, the majority voted to certify, so they got their way. By the way, it was mostly partisan. So you had the 2 Republicans that were voting no, and the 3 Democrats voted to certify, even though they could not, according to my guest the other night, Chris Kacheroff, representing Harrison Floyd, tells us that they were unable to do signature match verification on all of the massive amounts of mail-in ballots. All right. How are people to trust our justice system after seeing what's happening? I've always trusted our justice system, but not anymore. It scares me. And it scares me too. And I live in it. I work in it. My friend, Julie Hamill, the lawyer out in California, she's going to come on here in a few days as soon as we can find the time. And she's in the process of writing a book about how much, you know, she, over the course of between law school and where she is now in her career, she's come to the realization that so many of us have, that we can't trust courts. We can never trust courts to get it right. And if they do, it's oftentimes too little, too late. And when you can't trust courts, what do? It's a big problem. I mean, judges, even when they mean well, they just get it wrong a lot. And sometimes it doesn't mean that much if they get it wrong, but sometimes it means a hell of a lot. I've talked to more than one person when I was actively podcasting. I did several episodes where we talked to people who were on death row for things that they didn't do, and they got exonerated. But for decades, you had prosecutors and judges that were working just hand over fist to keep them locked up when it was obvious that they were not guilty, but they had to survive as best they could behind bars for decades and decades because something in the system broke down and it didn't work right. And a lot of times the problem lied with the prosecutor, and sometimes it lied with junk science. Sometimes it lied with corrupt judges. And of course, I'm not painting with a broad brush, and because most people in the system want it to work properly, but there are just some things that don't work, and it causes big problems. So I gave up years ago. Courts were going to be the answer to any of our problems or disputes. All right. Well, thank you all very much. I'm going to have to call today. We've been going at it over an hour, and I have a baseball game to go to tonight with my son. So with that, before you go on the way out, I want to, wait a minute, one more question. I can't. All right. Who's Fanny's boss? Well, I guess in a sense I am. I'm a resident of Fulton County, so I'm a voter in Fulton County. Those are the people who she works for. She's got one Republican challenger. She's got a Democrat challenger. So she's gonna have to win re-election. So the people who live and vote in Fulton County, those are her bosses. All right. So I've got to get ready to go to a baseball game tonight. I'm an Atlanta Braves fan. I'm taking my son, who's about to turn 13 next week. So, and he's a baseball player. So that's what we're doing tonight. And so I want everybody to wish the Atlanta Braves the best of luck, whether you like them or not. And before you go, I want you to, well, on the way out, I should say, on the way out, I showed you guys my new intro, and on the way out, here is my new outro. But please, thank you for being here. It truly means the world to me. All of your support. I could not be doing this without you. And we're going to continue to engage. We're going to continue this conversation. We got a lot of good things coming up. Don't forget, tomorrow we're going to be back later in the day tomorrow. I want to say it's 7:30 or 5:30 or 7:30. Anyway, I'll put it out on social media. I'll put it out on X. I'll post it here on the channel as well. Rachel Kaufman's going to be back. We're going to be talking more about YSL and the god-awful death trap that is the Fulton County Jail. Bonnie Willis is not moving her cases through there like she needs to. But it's not all her fault this time. There's others to blame, but it is just an awful, awful problem. And so this is consistent with us from the inside out. And you will not believe some of the stuff that we're going to talk about tomorrow. It ought to be great. It ought to be a great show. So anyway, with that, thank you all very much. And we will see you right back here on Inside the Law.